Hello, everyone. Please let us know if you can hear us or if there are any issues with audio. Um, I'd like to, on behalf of myself and of course, Ms. Chitra Narayan over here, who's very kindly agreed to attend this meeting and to speak along with us. Thank everyone who's logged on to this webinar, as well as those who attended in person and have taken the trouble to come here. Thank you all for coming down. We can begin now, I think, and start off the conversation. I'd like to begin by introducing Ms. Chitra Narayan. She's been a litigator of some considerable experience and recently has decided to, well, not that recently anymore, for quite some time has lent her expertise to the area of mediation, being a founding trustee of FCDR. And she has been spearheading efforts to make mediation a more viable option for both commercial and civil dispute resolution in both Tamil Nadu and India in general. I'm Rohan. I'm a partner with Samvad Partners, and I head the intellectual property practice. And I also work on a lot of technology-related issues with Samvad. So this conversation is basically on the mediation of technology disputes. So with no further ado, Chitra, if you have.
Yeah, I think we should start by, if you can, Rohan, explaining what kind of disputes fall within the scope of the expression technology disputes.
Sure. Yeah. So technology disputes, I mean, as the term is probably about as nebulous as the term technology law, in the sense that it sort of covers a very broad-based foundation of disputes which could involve software licensing, they could involve pharmaceutical patent propositions, they could involve trademark infringement. But at a very core level, I think ultimately disputes involving technology are ultimately disputes involving the intellectual property asset which underlies that technology. Not necessarily the ownership, maybe the licensing relating to it, which makes it sometimes a purely commercial dispute, or the validity of that intellectual property itself, which then makes it a question of whether that should have been granted a particular intellectual property, right? But in the end, even whether you're talking about licensing disputes, infringement disputes, oppositions against intellectual property registration, or domain name ownership disputes, you're basically boiling down the entire issue to a dispute around the intellectual property itself, the underlying asset. Yes.
Right. And one is a dispute where there is a relationship in place, and then there are disputes in this relationship. But I would think there would also be a situation, for instance, if there is an infringement where there is no relationship between the parties. So are these sort of the broad categories of technology disputes?
Absolutely. I would say that that the primary distinction which I would draw, if you really wanted to distinguish between the issues which arise in these disputes, is disputes where parties have a pre-existing relationship. They could be a licensor-licensee relationship. They could be various kinds of situations where parties had a commercial relationship or had that breakdown for some reason or the other. And of course, there's another category of disputes entirely where the parties don't know anything about each other at all. So you talk about infringement in that context. You talk about oppositions against intellectual property registrations, and of course, you could also look at domain name disputes in the same context. But yes, in both those contexts, of course, they are both technology disputes, and I would say the ability for both these disputes to be amicably resolved. It's clear that disputes where parties have a pre-existing relationship may actually lend themselves to amicable resolution more effectively, essentially. Yeah.
And since we're talking about a category or a type of disputes, Sarah, what would the expectation be when people have disputes that relate to technology, either the opposition or infringement or a prior relationship dispute?
Right. So I would say in those situations, what would happen is that a party is primarily a person who's initiating a dispute of this nature is either looking for broadly one of these things. One, they are looking to renegotiate or to enforce a commercial relationship, which relates to perhaps licensing, which relates to performance, which relates to some aspect of a commercial contractual relationship.
Mm-hmm.
They are looking to prevent someone from doing something which they are doing, which is basically the core of an infringement dispute, which is where they believe that with the strength of the intellectual property behind them, the defendant or the person who they initiated against is not entitled to continue a particular course of action. Or thirdly, they are looking to prevent someone from being given a right to an intellectual property, where they would initiate an opposition against, let's say, a patent before the registry, or they might initiate a domain name dispute. But essentially, in the end, the dispute boils down to seeking a declaration of some kind, or they would just say the software copyright is not original or not modern. So there would be a sort of defense in a copyright infringement suit. So the core of that essentially then is a way of saying that so those are the three sorts of things that people mainly are trying to do essentially in these kind of disputes.
So the reason I ask this is to sort of bring it into the context of the mediation and how mediation would be appropriate for these kind of disputes. Probably I should start by explaining what the process of mediation is. I do know that we use mediation, we use conciliation, as expressions often. I also know that, we all know that it is part of the Arbitration and Conciliation Act. So is it the same as arbitration? I think it could help to sort of talk about what these processes are. So to sort of put it in a very simple way, both mediation and conciliation are processes where a third party neutral helps parties who are in dispute to work out a resolution or a settlement of the issues that are in dispute between these parties. Both mediation and arbitration arise out of a contractual arrangement that these parties have. Yes, we will come together, we appoint a neutral, and this neutral helps us resolve the dispute. But where mediation and conciliation are different from arbitration is that the neutral has no ability or authority to decide the dispute. The neutral does not determine how the dispute should be resolved. It is for the parties to actually have a discussion and come and try and arrive at an agreement or a settlement on the basis of which they will resolve this dispute. So that's a difference, and a very fundamental difference between mediation and arbitration. The difference between mediation and conciliation is this. In mediation, the neutral facilitates discussions between the parties, whereas in conciliation, the neutral takes a more active role in the discussions. The conciliator would help the parties evaluate or give his or her evaluation of the merits of the dispute. The conciliator could give proposals on how the matter could be settled after hearing what the parties say. So let me also break up how the mediation process goes through. It starts with, of course, the mediator or the conciliator convening a meeting between the parties, and the parties share their sort of positions or their side of the case, if one were to put it that way. So each party shares the factual aspects of the case, and the other side hears, or the other sides, it could be more than one side, more than two sides. So the other sides hear, they listen to each other's sort of point of view on the case, what their merits are and what has transpired so far, what has led to the dispute. Once this is shared, there are, it's first a formal sort of presentation of the case, and then once each party hears the others, one gets into a more sort of granular, exposition of what the case is about. So each hears the other, and the idea is that you listen to the other person's point of view. What is the other person's experience? What are the other person's sort of standing on the case? What is their position? What they consider are the merits of their case. So if I have an intellectual property right that I'm, accusing X of infringing, I'm explaining the basis, the fact that maybe I have a registered patent, I have a patent, granted for my intellectual property, and so this has been evaluated by the authorities. This is my right, and you are using this wrongly. So this is my property, which I have an exclusive right, and you don't have it. And the other person, then conveys their point of view. This then moves on to the next stage of, saying, okay, this is where we are. How do we think we can resolve it? The parties generate options, and if it is a conciliation, the conciliator generates options on how this can be resolved. So what one does at this stage is move from positions to interest, and I'll explain it by saying this. I start with, I'm a patent holder. My right is to stop you from infringing this patent, and please stop using it right away, because this is the right I have. Whereas as you go along, the patent holder might consider that it might be I could probably license it to this other person, and get to return on this rather than sort of taking this through court and the long.
So that way, I suppose mediation is able to help parties arrive at some kind of a complementary relationship, where of course, a purely adversarial relationship will actually maybe commercially less viable for the parties, because actually it results in a situation where parties are, well, once you're placed in an adversarial relationship, you're not really able to visualize that relationship from the perspective of collaboration in the future.
That's right.
Okay.
It's also that the law looks at everything. An arbitrator or the court would look at it in a binary. You're right or you're wrong.
Yeah.
And that's all that the law allows you to do. But here, as the conversation goes goes forward with these parties, X who I allege is infringing my patent. So in this hypothetical, X has worked on this product and on this technology, and believes that she's entitled to intellectual property in it because of the time and effort that has been put into it. But she realizes now that there is a patent, and she's unsure if this infringement action is taken forward, whether she would be injuncted from using this patent, and there's all this effort that has gone into it. So X and I would probably go forward and consider, if I see the points that X has worked independently on this, I might want to discuss a little more with X on, can we work on this together? Can I license this to you? If you have certain aspects in your technology that I think I can use, why don't we work together to do this? So these are options that are generated as parties speak to each other and share more information. And
right. Sorry, just to interject. This information sharing is something which is also a feature built into mediation process, I would imagine.
Yes, and they're very sort of it's a very flexible process. So there are a few rules that are sort of very integral to this process. The first is that both parties must be willing to come and mediate. You don't. So if a party is not interested in this process or thinks that this process is it's not going to be useful, you can't compel a party to mediate. And I think it goes to the basis. Unless you're willing to do this, you're not going to look at options for settlement. The second is that what is discussed in a mediation is confidential. So assuming X and I are not able to arrive at a settlement, what has been shared, the fact that I may have made a proposal to her that I will license my technology to you, or why don't we see how we can get synergies from both our technologies. These are not conversations that will be repeated outside of this room where this mediation takes place. And it binds the mediator, it binds the parties, it binds counsel that may be assisting, or advisors who may be assisting these parties.
Actually, in that context, I mean, maybe this is something, even in our other discussion, we've not really covered this earlier, but one thing which just occurs to me is very important about mediation is that it's also able to preserve the confidentiality of discussions underlying, these fairly secret or fairly complex technologies, which the originator would prefer to keep secret. And probably as a dispute resolution process, it lends itself more to that confidential relationship, to confidentiality underlying that technology. Could you elaborate on that relationship of confidentiality in mediation in general?
So I think I need to sort of touch on the regulations of what is the law surrounding mediation.
Sure.
So in India, we have a law governing mediation. See, as I explained earlier, these are functional differences in mediation. The other expression which one would use for mediation and conciliation would be facilitative versus evaluative. So the difference is that the conciliator has a greater responsibility in conciliation or in an evaluative mediation. So, but in India, the way we've taken this is that we've had under the civil procedure code, we had an amendment in 1999 where the courts were given the power to take up a suit that came up before you and to evaluate if the parties, if the matter or if the case was amenable to a settlement, and could then refer the parties to go for mediation.
Sure.
You have court, so you have court annexed centers all over. I think most district courts and almost all the high courts in the country have court annexed mediation centers where cases are referred. So what the Supreme Court has said was that is that cases that go to the court and to the court annexed center are mediations. We also have the Arbitration and Conciliation Act, and Part 3 of the Act deals with conciliation. And here, it doesn't define who a conciliator is. It just describes the process. So it talks about the process being a process that parties will start based on agreement between them. The dispute will start on the basis of an agreement between them. They can appoint any person as a conciliator. It talks about preserving confidentiality in the process. It talks about the conciliator making suggestions for settlement. And if parties arrive at an agreement, that agreement is the same as has the same sort of standing as an agreement, an arbitral award on agreed terms. And taking that further, what the Arbitration Act says is that an arbitral award can be enforced as if it were a decree. The same status, is given to a conciliation as well.
This is the AFCON's construction.
That's right, but it's a statutory.
It's now a statutory provision.
It's a statutory provision under the arbitration.
Okay. Elaborated by AFCON.
Yes, of course. Now, going back to the point you raised about confidentiality, so there is a statutory protection both in the mediation process under the mediation rules of the respective high courts, as well as under the Arbitration and Conciliation Act that protects confidentiality of information shared. I do think that in case of technology disputes, the party may be a little wary about sharing because one doesn't know what the outcome is. One doesn't entirely trust the person, say X, who I'm alleging has infringed. I'm not going to share the entirety of my information. The mediation process is a process which we prefer to have with both parties together because they are the persons who need to resolve and decide on how they would want to settle this dispute. The decision, the autonomy is entirely theirs. But what we do if there is a reservation about sharing information is we have what are called separate sessions or caucuses, where the party, I'm able to share with you, Rohan, the mediator, the information about my technology and explain why I either believe I have a strong position here or that these are my concerns because this is the technology and this that I have and this is the technology that X has. You would be bound by confidentiality not to share it with them, but you can help me evaluate how, if either as a technical person, yes, where my case stands, and help the conversation forward. The other way I could do it is also to call upon an expert. We call a technical expert or a legal expert on the subject to participate in the mediation, with whom I share this information. And what the technical expert shares for X and me to sort of take this forward is not the technology, but a summary of that person's evaluation and strength.
Sure.
the patent that has been granted or the technology.
Somewhat like an amicus in a way.
Yes, like an amicus.
But of course, yeah.
Who's also bound by confidentiality, and what comes out in the mediation to help the process forward is only an assessment of how strong the technology of the right is.
Understood. Right. So that way, I guess, one other thing which I've considered, like maybe another reason why mediation would be useful or beneficial towards the towards technology dispute resolution would be that, I suppose, at the fast pace at which technology moves, you often have situations where you find incidents or where you have disputes over commercialization, but by the time those actually reach some kind of a resolution, you end up in a situation where the entire dispute is irrelevant because the wave of technology which these parties were trying to ride has passed quite some time ago, and the underlying dispute. I mean, it's worth pulling out a couple of interesting, real life situations. For example, we've had the Bajaj Cbs patent infringement dispute, which had been going on for about a decade and a half or so. And now we know that somewhere early, I think August this year, that dispute was amicably settled. And I would imagine that at least one of the factors involved in the settlement is that the technology underlying this dispute, which pertained to a fairly unique spark plug for motorcycles, is not really relevant any longer. And I guess in that context, litigation or arbitration does tend to take time in order to resolve disputes, and that may not be the best solution for fast-moving, essentially technology-related disputes. So in that context, we talk about mediation and how it's able to help resolve these disputes.
Yes, there are many advantages. I think synergies, what I call it, that mediation has in the context of technology disputes. The first is, of course, the time that you were talking about. So with technology moving fast and with an intellectual property right holder wanting to monetize the property that he has, the exclusivity of the monopoly that the law gives him, within the time, it's limited. So I want to monetize it and not really, be in a dispute with someone during this period. So time and parties are able to are entitled. They have the right to set a time within which this should complete, because any one party can pull up. So you could set, say, 3 months, you could set 30 days, depending on the complexity of the dispute and the matters that need to be discussed. The second is the autonomy that you have in how you want to resolve this. It doesn't have to be so-and-so is infringing, will be stopped. It could move to other issues. It could have a more sort of...
if you don't mind, other issues, like, for example, you could do you mean that you could resolve a deeper underlying issue essentially, or how
you could do that? Let me give an example. Yes. I don't know if Tom Petty is your generation, but Tom Petty had this song "I Won't Back Down."
Right.
And there was this singer called Sam Smith, different generation. He wrote this song, and Tom Petty found that there were similarities. Rather than go to court, he said, this song sounds like mine in portions. When I read about this, I did go listen to both the songs, and I did find that there was something in the refrain, yes, which was similar. So Sam Smith says, look, I was born 3 years after your song came out. I did not copy it, yes. But they had negotiations, and they came out with this very good sort of understanding where Sam Smith agreed to attribute 12.5% of the originality in the song to Tom Petty, and he would get 12.5% of the royalties that Sam Smith wanted. Now, what was Sam Smith's? This was his first album. I mean, and if this had gone to court, and this was, it would have affected his career.
And Tom Petty was an established star, so obviously
yes. Big difference. Yes. So my interest, or Sam's interest at that point in time, was, I need to resolve this. This can't get bigger than here and now, and I need to move on with mine. So the arrangement that they arrived at served this interest. Rather than a fight about, no, this is my song. there is just probably a few strains that are similar to your song. Rather than fighting that out, taking their time over it, and either album being injuncted from being broadcast, this was the way they worked it out. So his interest as a young songwriter, singer, was taken care of in this arrangement that they worked out, which a court would not have been able to resolve in this way, in this manner.
They'll have to find in favor of one person or the other. I mean, I suppose a lot of analogies could talk between that and situations involving young startups and established multinational companies, not just on infringement, maybe even on commercial relationships and such like. So yeah, all right, that's interesting.
Another sort of dispute that we mediated was it related to this young couple. The wife had done a beautician's course, and she took a franchise from a well-established brand in beauty salons, and she set up shop. But they're young, they didn't sort of anticipate or plan ahead on what the costs and what the efforts would be in setting up and running this. The parlor wasn't going as well as they expected. There were, defaults in paying the royalty, the franchise fee, and when it came to mediation, there were two ways, that they terminate the franchise relationship and these people start afresh. They'd invested a lot in this, and it was going to be, it would break them. But what they, when the parties came face to face and they spoke about all of this, these difficulties, and why they had not managed to break even or defaulted to paying fees, and the franchisor agreed to sort of give them a slightly longer run. They paced the repayments in a manner that would be easy for them. They agreed to step in and help them sort of run it a little bit.
Okay.
So these are possibilities.
These are solutions which are actually possible because it reached the stage of mediation. Yes. And if I may ask, how was it able to reach? Was it court referred, or was it something which the parties agreed to do in order to resolve the dispute?
In this case, it was a court referred.
It was court referred. Okay.
But once the process was explained to them, I think they wanted to take advantage of it and see what they could do with it.
Okay.
Because it gave them the autonomy and the ability to work out the solution that they sort of knew best.
Right.
And in technology disputes, I mean, you have invariably a court which is a generalist court. This court is going to say, yes, from what you say, there is a breach, or there is not a breach, or that you're entitled to the intellectual property right, or you're not. Parties are able to, I think, knowing what the problems are and how far they've come, how they've come along, able to sort of fashion a settlement or a resolution that works best for both of them, which a court would not be in a position to do. This is not to take away from the work or the role of the court, but just to say that this is more appropriate, and this is worth sort of exploring for parties who have disputes.
And so I mean, like I said earlier, with the two kinds of disputes around technology which exist, it may be that disputes between an infringer, especially a deliberate infringer, and an intellectual property rights owner, are really not the sort of thing which can lend themselves necessarily to mediation. So, like deliberate piracy, for example, is something which the rights owner is just going to be incentivized to try and enforce that. But yeah, as you said, those are something which the courts can really help them and will really be able to help them. Again, disputes regarding the actual validity of intellectual property right. I mean, we talked about that aspect as far as arbitration is concerned, and we know that. Again, if anyone has to reach a determination of that nature and decide about intellectual property right should or should not exist, that is actually the binary kind of question which the courts do need to be able to get into.
So I think, in this context, in the context of technology disputes, particularly opposition, I think there are a sort of a set of disputes that I think are not amenable to arbitration or mediation, because it is a determination of the person's, I mean, have I met the requirements of law when I have applied for this patent or for this trademark or copyright? And that is a matter that the authorities have to decide. I don't think Rohan and Chitra challenges Rohan's right to get a patent, we decide between ourselves that,
Yeah.
fine, Rohan,
It's not
you
really-
applied for a patent and I'm challenging it, or a trademark. We don't decide that, okay, you keep it, you apply and you go ahead. And,
That's true.
So it's not a matter, it's not an inter-party sort of issue that we work out.
Yeah.
But having said that, there is a recent amendment to the Singapore Arbitration Act, as recent as July 2019, which says that intellectual property disputes will be arbitrable, not, never mind what any other law says, including international disputes, that parties may have taken to Singapore or to the SIAC to resolve. And it says, notwithstanding any law in any place on whether disputes are arbitrable or not.
That's fascinating, actually.
Yeah.
Because the law has been tending in that direction, but to have this fairly clear statement on the subject is very exciting. Because we've had carve-outs of the Euro versus Telmax decision, other decisions, the Bombay High Court, such like. But that's interesting. And okay, so that's obviously also serves as a good counter to my point regarding the immediate IP disputes. I guess in that context, it's worth noting that the Delhi Trademark Registry in 2016 did refer a bunch of trademark opposition and rectification proceedings to mediation. And I think what the registry recognized is that while people's expressed positions are that this intellectual property right should not exist, or that I have a problem with this being registered, their underlying positions could be far more commercial in nature and something which could actually be resolved. So without necessarily having to get into the complication of having to cancel a particular trademark or to reject a particular application.
Yeah, and I think there are two levels of what was resolved here. The first is that I oppose, the trademark on the basis that I have something similar, the grant of the trademark would in effect my property right. But I don't think that sort of dealt with the trademark authorities' evaluation of the application on its own merits, and they're finding that yes, the trademark ought to be registered or not registered. I think that's a separate exercise, which would not be amenable.
Absolutely. I think what is interesting about the trademark registry is to recognize that need not be the actual issue underlying these oppositions, and that these could be resolved by just getting the party, like you said, to sit across the table from each other and talk, essentially. So the other thing which I wanted to cover to some extent is that there are variants on mediation as well, right? Which might be also in certain situations suitable for technology, like for example, early evaluation and such like. Could you talk about those in detail?
Yes, so these are appropriate dispute resolution processes. Some courts in the US, in fact, insist that intellectual property disputes go to neutral evaluation and come through. So you have an expert either in the law or technically, a person who's an expert who, before whom both parties or all parties present, their individual cases, and the expert, on account of his or her expertise, is able to sort of give an opinion on whether this technology would be entitled to registration or to the grant of a patent.
Right.
Would also give an opinion on whether there was an infringement.
Right.
So mediation also actually would accommodates these processes. So I was talking about facilitated mediation and evaluated mediation. You could have a mediator who has no subject matter expertise, but who is trained as a mediator, helping the parties in the discussions. And you could bring a neutral evaluator if parties are not able to sort of work around a particular situation of, technically, is this something that would be granted patent? Technically, is this an infringement? And that answer sort of would help them decide how they're moving forward with how the matter should be resolved. You could call an expert too, give a neutral evaluation. I also spoke about it in the context of confidentiality. So you can have an expert
who's unconcerned
with the proceedings, yes, giving an evaluation on whether there is an infringement.
Right. That's
which helps the parties go forward. And parties also, before they go to court, some parties may, on the advice of counsel, get an early neutral assessment individually or together, which helps them decide what they want to do in this case and how heavily they want to litigate.
So that's interesting. That's it. So that therefore, like something like early neutral evaluation would actually be complementary to an existing mediation process. They're not necessarily they're not alternatives. They could work together.
They could work together.
Okay.
I think the Delhi High Court has, in fact, in the trademark matter, directed the parties to go to mediation. There were some aspects that were resolved and went back to court, and then the court said, look, these parts we send back for early neutral evaluation. High Court has used early neutral evaluation more extensively, I think, than the rest of the country.
Right, that's true. I mean, so this is the Baba Masala Company's decision, basically. We'll share some of these materials which we have access to all the registrants who provided an email address, so that we might have something to look at afterwards. Yeah. So then the other question which arises in this context is, I think again you mentioned this earlier, logistically also, like given the pace at which this sort of thing works and the speed of necessary speed and efficiency in this. Again, something which we only discussed in passing maybe earlier, but maybe worth getting into is, how do you think ODR, online dispute resolution, is able to address the necessities of modern mediation requirements in commercial matter and technological mediation matter as well?
So the online dispute resolution now, I think, has such a vast, fascinating range of applications. You have algorithms that are used for sentencing, possibly. That could happen. You have algorithms that could, in negotiation, possibly suggest or throw up on an assessment of factors where a median is, or where the parties could possibly agree on, say, a rate of royalty that's might be what best for them. That's one part of it. The second is the platform that it provides, where parties that if it's an infringement and one party is in India, the other party is in, say, Spain, and you're able to overcome this physical distance and actually have a mediation online.
Right. Absolutely. Okay. Yeah. That's yes. Absolutely. I think that way, in terms of online distribution, like the WIPO Mediation Arbitration Center has probably been leading the way, and for quite some time, I think, with fairly well-established procedures for like domain dispute resolution, which don't require a spoken word from counsel for either party, which is fairly rare in these kinds of situations. So yeah, I guess it shows that there are possibilities. Well, of course, that's arbitration, but there are possibilities even in this kind of dispute where although of course mediation, I would imagine, is the kind of thing which requires a steady back and forth of ideas, and not necessarily just be able to be solvable on the basis of pleadings.
Yeah, and it could be, if it's a very sort of without sort of having the human presence. Technology has been used to sort of resolve custody disputes in the court in Nevada, where they actually have a list of sort of yes/nos that each party, each parent to the custody dispute actually expresses their opinion on.
Like a checklist.
Yes, and sort of it's if they're not able to sort of match on all factors that are there, for instance, vacation, who has whether it's sole custody or joint custody. Education takes responsibility for the monetary aspect. If they agree on all of these sort of boxes, then that's the dispute resolved. And it's only when they're not able to match each other's expectations here that human, there is a human mediation involved. So things are moving at a great pace. We also have what is called the Singapore Convention, which
Yes, I was hoping
which
you
is
would
called,
elaborate on that. That's very, very interesting. Actually.
which is a convention like the New York Convention that sets out the grounds on which international mediated settlement agreements will be enforced by countries. So signatories who ratify them will make domestic laws in terms of which, which will adopt the grounds that are there in the Singapore Convention. And I can go to, if Spain were a signatory, I go to Spain with my mediated settlement agreement.
Okay.
And if the counterparty has initiated proceedings in Spain on the same issue, I show the mediated settlement agreement as a defense, based on the basis of which, the proceedings are stalled. An evaluation is done on the same grounds as the Singapore Convention to see if it meets the enforceability requirements. I could also take it to Spain where there are assets, to enforce my mediated settlement agreement if a party were not to
cooperate.
But really, this is just this convention gives parties an assurance that this mediated settlement agreement is recognized and enforced. Typically, because I've agreed with X that these are the terms on which I will settle and negotiated, I've agreed on something that I think I can do. It's very rarely that you find someone actually breaking away from this. It's voluntary, and therefore people tend to implement what the agreement is. But just to be on the safe side, there is this convention as well.
Okay, that's interesting. Yes, of course. No, because yes, that is a very good point. It would be good if you could talk to some extent about the extent of enforceability of these mediated settlement agreements, because I think a challenge we often face with sort of trying to promote mediation as an option to counsel and companies is that they feel that it's very likely for a counterparty to be amenable to a particular mediated settlement agreement and then turn their back on it. I think you already spoken a little bit about this actually when you talked about how they have the effect of a decree of court and how in the context of the Arbitration Consideration Act and AFCONs. But if you could speak a little bit more about that, that would be helpful.
Yeah, so the Singapore Convention deals with commercial disputes that are mediated. So it won't be a consumer dispute, for instance.
Sure.
So both parties need to have this as a commercial dealing, a commercial transaction. If an agreement is entered into and one party does not comply or implement the agreement, I could take this dispute to the country or the place where the counterparty has assets and apply to the court for enforcement. The court looks at this agreement from about 4 or 5 points. They look to see if this agreement is, if the party, and these are grounds that the counterparty can raise, that party was under some incapacity. In the context of commercial relationships, one such incapacity could be that there was an insolvency proceeding that was initiated against the party, and therefore, the party could not settle with one creditor to make a payment. So that's one example of incapacity. The other ground is if the agreement is null or void or inoperative. And these are expressions in language that are borrowed partly from the Contract Act and partly from the New York Convention. So this is a ground on which it could be not enforced if the court finds it is not right. The other grounds relate to the terms of the settlement themselves. Was it the agreement between parties that they would not take formal proceedings for enforcement? Was it the agreement, or has the party by complying with the agreement and performing under the mediated settlement agreement now left nothing for the court to enforce? These are aspects that the court goes into. The next ground is a ground relating to mediator standards. So one expects the mediator to be a neutral person, an impartial person, and if the mediator, actually had a relationship or knew one of the parties well, this was not disclosed to the other party, and as a result, the other party, there has to be a causal link.
Right.
The other party actually enters into the settlement without this knowledge, but would not have entered into the settlement or even the mediation because of the relationship between the counterparty and the mediator. So mediator standards, mediation standards is not ground. The last ground is like it is in the New York Convention and in our Arbitration Act. Would the mediated settlement agreement be something that would be opposed to the public policy of the country that is enforcing it? And is the subject matter of the mediated settlement something that is not amenable to mediation under the law of the country that is enforcing it? Going back to, could parties have agreed that one person is entitled to it?
Right, the validity of the patent existing in such. Right, okay. All right. So in that context, I think one important development from regulatory perspective, I think we, at different points, we've captured certain of these developments. But I think there's been a fairly important recent development with regard to the relatively recent development on the amendment of the Commercial Courts Act and the idea of pre-institution mediation now being a requirement for for cases which don't exhibit the same kind of urgency. In your experience as a mediator, have you seen that this is actually in any positive way influenced, or let me put it differently? What do you see as having been the advantages and disadvantages of this particular amendment? And do you see that like in scope of improvement?
Yeah, so it's more than a year.
Sure.
The amendment was in August 2018.
Right, so not so recent necessarily, but yes.
No, but so I'm trying to relate to what has happened in this year. What the law says is that it is mandatory for commercial disputes, and commercial disputes includes intellectual property disputes,
right.
Contractual disputes, and the law says that it is mandatory for a party before they approach the commercial court to actually attempt mediation. The law says that this mediation process will be managed by an authority, and the authority that has been named is the Legal Services Authority. The law also says that if you have an urgent interim order that you require, then you need not go for mediation. You can approach the court directly. Now, often we've seen, I think you'll agree in your experience, that people tend to approach the court when there is a need for an interim order. That is really the trigger for people approaching the court.
Yes.
And therefore, most of the cases are able to sort of bypass the requirement of mandatory mediation by filing an interim application. Who's to say, this is a genuine application? But I think you'd agree in most cases it is. There is a need, and that's what propels parties to go to court.
Yes.
Then, so this is how. So the way I see it, the fact that there is a need for an interim order should not take away from attempting mediation.
Right.
The two are not sort of mutually exclusive, and the law, I think, will take a little effort to sort of accommodate the fact that these are not exclusive sort of happenings, and if someone needs an interim application, that goes through its own motions. Independently, parties could attempt mediation.
Right. So it's not necessary. So yeah, one possible solution would be allowing parties to mediate while an interim solution is, or while interim order is being argued. Of course, just
or immediately after.
Or immediately after. Yes.
Because that also helps parties assess. So one of the things parties do in mediation is are required to do some sort of, they evaluate their strength in the case, their right to property, and they also evaluate what is the likelihood of me winning this case if I were to go to a court. Which is why I think in technology disputes and intellectual property disputes, lawyers and parties expect the person who is mediating the dispute to be a technical or a legal expert on the subject.
Yes.
And the expectation is that this person is evaluated, helps the parties understand where they stand in the case that they've sort of presented, or the positions they've taken in the mediation.
Right.
And do reality testing, which we call what is the best alternative to a negotiated settlement and what's the worst alternative to a negotiated settlement. So if you were to go to court with this, what's going to happen? So one factor is time that you refer to. The second is the costs of litigation. And the third is what is the outcome likely to be? Are you able to say with a fair amount of certainty that this is what the outcome is, and therefore might it not make sense for you to look at how you could settle it here a little more seriously?
Understood.
So the expectation is that the mediator be an an expert.
Yes,
And,
this is part of a conversation we were having earlier. Maybe a debate on this particular point, essentially, right? For, sorry, you were saying, please.
So, I think the important role the mediator plays is that the mediator is a neutral, has the ability to listen, not impose opinions on the parties, and that's really and is able to carry the parties forward, parties who might be in hostile situation, take them forward, engage with them, and make sure that they are sort of carrying on this discussion.
Yes.
Which an expert, unless the expert is trained in mediation, may not be able to take forward. The other problem with an expert, though I think there is a lot of merit in having an expert as a mediator, but another problem that one should sort of anticipate and provide for is the expert being, sort of imposing that person's view on one or the other.
Understood. So I guess this ties into the fact that of course I'm of the opinion that there are at least some disputes where, while the expert need not necessarily have a specific sectoral knowledge, the expert might be somebody who has at least an idea about intellectual property, or the expert may be somebody who has an idea about very broadly the technological field which is being referred to, and is therefore capable of understanding a few of the commercial nuances inherent in discussion. Like, for example, if you're talking about dispute regarding the licensing of software to be loaded on motherboards or hardware essentially on motherboards, then you're going to have somebody who is capable of understanding where that dispute fell apart, whether that arose from a failure of performance or a failure of payment, and in those, there is the issues involved are both intensely commercial and also quite intensely technical as well, and so these issues are inherently interlinked. But I take your point in the fact that even the expert has to be somebody who is a mediator first and an expert second, because I think the process of mediation requires an understanding of the relationship of the mediator vis-a-vis the parties, and I guess often an expert may wish to put their opinion about the solutions the parties may be able to arrive at. But so I feel it doesn't necessarily take away from the role of technical expert, but then it is subservient to the role of that expert's training as a mediator first.
That's right. Yeah. And I think the expert needs to be mindful. I think parties do expect some evaluation or some guidance from the mediator, and if it's an expert, especially if it's only a technical issue.
Sure.
I mean, there is value in having an expert for intellectual property disputes.
Absolutely. So I think we are. I think we should open up a few questions if there are. I see that we have at least one question on chat. I think now it's a good time to sort of open up Q&A. And if anyone who's watching has any questions which they'd like to raise, and or if anyone has like to raise any questions, please let us know, and we'll open it up to the one question I see which is being put up online. And after that, we can even take questions from those who are here at the meeting. So this is just merely a issue regarding the the audio.
The main advantage of mediation is win-win situation for both.
Right.
It is not there in other processes.
Right. So
I think that's an important point you brought up. That in litigation or arbitration, you have a winner and a loser, whereas here parties are able to work something out.
Right. So I've actually heard it phrased differently, in the sense that oftentimes people say that mediation arrives in a situation where you're able to find both parties equally dissatisfied at the end of the proceedings, but they are equally dissatisfied. No one party feels that they have been.
Very rare.
Yeah, that's true. Does anybody have any questions?
What is the time limit?
So I'll repeat the question. So the question is, what is the time limit for probable settlements in mediations? What are the timelines like?
It's difficult to have a sort of one answer. It depends on the complexity of the case. There are mediations that are settled, because parties are engaged with the mediation on a day-to-day basis. It could be settled in a few days' time, more complex sort of mediations require the parties to sort of, it takes time to sort of unravel issues and move them from, positions to looking at, how can we do this together? How can we collaborate to arrive at a solution? That takes time. Sometimes it takes time for parties to go back, think about it, yes, and then.
So how do we control that? We go for mediation for a quicker settlement.
So the question is
convention which helps us in fixing up a time frame.
Okay, there is no convention. I think the nature of the process is such that you must give it the time that is required for parties to work out what they need to. But bear in mind that both parties are working on with the knowledge that if the other party doesn't think that they are up to speed or collaborating or working enough or discussing enough, that party can pull out of the mediation, and that's the end of the mediation. So I think both parties need to show some level of earnestness in resolve.
In technology mediation, you recommend for pre-litigative mediation or post-litigative mediation?
I think there's value for both. Before you file a case, if you were to go in for mediation, your position isn't very hardened. You haven't really spent too much money or time on the litigation. And so you're a little more open to, looking at a collaborative solution. If you were to go to court and you exchange pleadings, so you know what both parties' case is, that might make you a little more certain about where you stand in the case because you've sort of made an assessment of what their defense is. And so you might be less willing, but likewise, the other party now also has an assessment of what, where things stand as far as the case is concerned. They're able to evaluate where the respective standing is and might then be more willing to mediate. This, once you've shared pleadings or documents with each other, or discovery, which is very extensively used in the United States, we don't use it as much here. You have a fair amount of information and you're also able to make a better decision on how this can be resolved. So there is a plus and minus for both.
That's what I asked him, which you recommend.
I'd step in here and just say one thing. Very often you have these situations with both, but of course, ideally parties should be able to, I would just say ideally parties should be able to get into a pre-litigation mediation because they are able to at that particular stage, what do you call it, as Chitra very put it, they are able to resolve disputes without anyone having taken a firm stance one way or the other. Because once you get into the process of litigation, when you submit your pleadings, you sort of like, you put your stance in stone, essentially. You said, this is what my position is and I'm not going to back down from this position. And the other side has done something very similar by putting it in the form of pleadings. But that being said, in an imperfect world, as one we live in, it is thankfully the courts which have sort of pushed parties towards considering the option of post-litigation mediation, and that is actually a lot of the reason why I would say mediated settlements have worked out because the courts recognizing the need for parties to get into post-litigation mediation have done so. So ideally, pre-litigation would be a good option. But I think in this situation, we should be happy that our courts are supportive.
They are recognizing the post again.
Yes, that's what I would say.
Especially in technology-related issues, there's a lot that keeps coming. It's a very dynamic area. Changes every day, and especially now we see with the data protection bill that's going to come out. Given that technology law specifically is an area where the law is silent on several issues. Like even though we have intellectual property regime, with the advent of new technology, the law automatically becomes silent on several issues. So given that scenario, do you think that mediation is a better option to be resolving the silences in the law, or does that pose a disadvantageous position to parties in mediation? How do we reconcile the need for law to be established with speedy reconciliation?
That's a great question.
I'll just repeat the question for the benefit of the online listeners. The main point is that in the context of technology law, you've got advances happening on such a regular basis that positions will change on a regular basis. And the question which was being raised in this particular context is mediation capable of keeping pace with these modifications and with the changes in these regulations? I guess the other important thing which I'm thinking about in that context, which I'm just, is this changing? Are these changes? Is the fact that disputes would be mediated in this context actually take away from the ability to contribute to developments in the law by basically, by taking disputes out of the realm of taking cutting edge disputes out of that realm and putting them into the sort of commercial resolution which they require? That was just something I was thinking about in the context of what you're asking. But yeah.
Yeah. So I think mediation plays a role when regulation has not kept up with changes in technologies, because it then helps parties to fashion out, how they would want to resolve this in the absence of a straight answer in the regulation. So I think there is that value that's being provided. How to put this? There is this expression used that mediation takes place in the shadow of the law. It's sort of it's a very beautiful way of putting it. It conveys a lot that you can't agree to something that's illegal. You can't agree to. So, in the absence of regulation, we'd be agreeing to something, but we'd only be looking at the existing regulation to sort of assist us in fashioning something that remains legal. That's not an illegal settlement. So you would still be looking at what regulation is in that aspect. But I think you are meeting a gap that regulation has in that context. And going to your point, that I'd love a day when there's so much mediation taking place that you don't have precedents. But you're also going to the point that there are certain cases where you can't mediate because you need a precedent or you need a determination on certain points.
This put me in mind of actually when which I wanted to bring up, this Roche versus Cipla mediation, which is basically this patent infringement dispute between Roche, the originator company, and Cipla, the Indian generic company, over Tacera. They are allowed to patent the pharmaceutical product. And the courts actually passed an order referring this dispute to mediation in 2014. And it was interesting because there was a lot of online commentary saying that the courts sort of passed on an opportunity to decide the law on a complex point and such like. And that of course there was then, and I think we've come past that point where, of course, while that particular mediation didn't work out, they very recently, again, I'd say they probably like late in 2018, they amicably resolved their dispute also. And I would say that at least some part of that was played by the mediation in getting the parties to have some kind of conversation with each other and realize that there's at least a possibility for seeing a compromise through. But to summarize the point, I would say that as you very validly pointed out, it's not going to be a major problem, I guess, from that perspective, that mediation is going to take away from the determination of complex legal questions, because we just don't have enough of those yet. But more importantly, the purpose of a legal dispute is to resolve the problem between the parties, I suppose. And ultimately, if that is not happening, then I guess if that's happening through mediation, then that's more important that it's happening than that we have complex legal disputes.
And though I'd call arbitration a mainstream dispute resolution procedure now in commercial disputes. We haven't reached the stage where we are sort of not, when it's displacing the court or that, you're lacking precedence.
That's true. That's true. There are too many barriers for that anyway. Does that answer the question?
Yes.
Okay, fine. Yeah. Does anybody have any other questions about
I
it?
have a question.
Please.
So, how are penalties guided under mediation? Like, for instance, for the enforcement of a decree, if someone fails to do so, like the CPC has laid out how there will be some reserve person if they're not doing the idea of obliging to that with a certain set amount of period. So, does mediation also regulate penalties in that instance, or how does it enforce a person to oblige to a certain settlement that has been accepted in the proceedings?
Yeah, for the benefit of the online audience. So the question basically says, does mediation have a penalty regime? And if so, how is it enforced, basically? Is that broadly the question? Yeah. All right.
So there is no penalty regime under mediation. It is voluntary. But going to your question that, parties have entered into a mediated settlement agreement. Under a domestic law, if it is a conciliation, that is, if the steps under the conciliation law are followed, that is, there is an agreement, there is a neutral involved, there are discussions, there are settlement proposals that are exchanged. These are the requirements, and they arrive at a settlement. It's enforceable like a decree. So you would take it to a court, and the court would enforce it or execute it in the manner that it executes a decree. The only thing here that we must bear in mind is that the court would be bound by the four corners of the settlement agreement. Cannot go beyond that. But if we've agreed that X would pay Y a sum of money, the court can execute it in the same manner. It is the person is a judgment debtor in a sense, and that would be executed.
Yeah, so I think that's the most important aspect. The enforceability of mediated settlement agreement has become far stronger, I suppose, now, essentially, not only with the commercial court side, but with the Singapore Convention as well, that perspective. Anything else, anyone?
Madam asked about time frame for mediation.
Yes, sir.
Mediation done through courts, there is a time limit. Previously not there, but now.
That's right. And we're grateful to under the court rules, high court rules, most high courts have a 90-day period within which
120 days now. 120 days.
120 days.
Yeah.
Within which
60 days given for mediator. Then if he still feels that it will be settled, he can ask for 30 days extension by a letter. And after that, if not settled within 200 days, court can recall the bundle and proceed with the case.
Right.
So would it change the option we prefer? Pre-litigation or post-litigation litigation?
No, that will become a suspended admission until such time.
No. You asked for whether we should go for pre-litigation or post-litigation, right?
So let me make 2 points there.
The first one,
Pre-litigation.
post-litigation, we have a time frame.
No, pre-litigation. Pre-litigation, regard to pre-litigation, there must be an agreement, clause in the agreement that we opt for mediation, like
Yes,
going for arbitration.
That would be there. But there is no
Is
time
that-
limits.
we get
It's
proceed.
left to each parties.
Yeah.
But if it comes to post-litigation, court
Yeah.
has a time limit. So
Exactly.
would it differ? No, whether
Would the opinion? No, I don't think options. You're saying basically would options change knowing that there is a post litigation.
Why?
I would say that once you're already in litigation, then like what you call it, options become far more narrowed anyway. So that is the
Because some parties utilize this mediation as to prolong the case.
prolonged
That's why limitation is being
placed.
Right.
What is the position of this mediator, arbitrator, conciliator, whether it is judicial or quasi-judicial?
I think the arbitrator exercises a sort of a judicial because there is a determination made by the arbitrator, much like a judge, except that the arbitrator is a private
With
appointee.
regarding to mediation?
A mediator, as we know it, does not make any determination at all. A conciliator makes an evaluation but no decision. May help the parties evaluate the strengths of their case, but again does not make a decision. So it's only suggested.
So these two things are coming out of the framework.
Okay, I think thank you for your questions also for people who participated in making this an interesting interactive session. I'd like to take a few minutes just to talk about one of the reasons why we had this session, which is sort of to drive interest in a conference which happens on an annual basis. Well, right now it happens in Bangalore. It's called iTech Law. It's the iTech Law is basically short for the International Technology Lawyers Association. It was founded as far back as the early 90s in the US and is now an international organization, sort of drives conversation around important issues at the cusp of law and technology. It's an association which tries to bring people together in order to have these discussions and these dialogues. iTech Law has an annual India conference. In fact, they have a conference. They have 4 major conferences around the world, basically, usually 3. So they have one in the US, one in Europe, one in India, and, well, once every alternate year, they have a conference in East Asia. So we have our iTech Law International the India conference coming up between the 29th and the 31st of January. And it's a very interesting conference to attend if you're interested, if you're excited about these issues at the borderline between technology and law. There will be discussions on data privacy. There'll be discussions on regulation of artificial intelligence. There'll be discussions on the latest developments in intellectual property, including the orders of the Delhi High Court in that context, with regard to dynamic IP based infringement orders. And there are fairly nuanced discussions around, for example, urban mobility, around the role of technology in the legal space as well. So for those of you who are interested, I will be circulating, we'll be circulating a bunch of materials anyway, which have some connection with what we've talked about already. So some will be case law and such like. So if you have not shared your email, I encourage you to do so. So we'll make sure that you all get those materials as well. And along with that, I will circulate a small one-pager just containing important links to iTech Law, and if you have an interest in registering, then a link to the registration as well. Early bird registration expired yesterday, but we have a coupon open which allows early bird registration to stay open for those who attended and participated in this particular webinar. So thank you everyone for being a part of this, and yes.
Thank you.
Thank you, Chitra, for your time and for your expertise in this matter. My pleasure.